Good morning, everybody. Death, taxes, and regulation. How I learned to stop worrying and love the health and safety inspector. Forgive the title. My sense of humour is known to be a little weird. An explanation is available to those not from the 20th century. But regulation is one of those inevitables of life. So enough of seeing me. Let's get started. I've met business people who are afraid of me. Some even loathe me, but most accept me as, dare I say, a necessary evil. Then there are those that look to me as a source of up-to-date, accurate and reliable information, and the same goes for all of my colleagues. And today I hope to be able to cut through some of the myth that surrounds regulation, in particularly health and safety at work regulation, and suggest practical ways to understand and achieve compliance, to reduce the burden, to aid understanding, build trust, and demonstrate that good health and safety needn't be excessively costly. I hope too that you'll see that our main weapons aren't fear and surprise, but sound common sense. As with every good presentation, there's always a list of contents. That is a basic framework about what we will talk about today, and it won't necessarily be in that order. There's often a fear about regulation and that people like me are just there to put barriers in the way of business and wait for an opportunity to pounce, clipboard in one hand, prohibition notice in the other. There's also a plethora of myth, try saying that after a pint or two, built up around so-called health and safety, mostly put about by the tabloid press and certain TV motoring presenters who in reality wouldn't go to the toilet without the safety officers say so. Politicians too have made a point of reducing the so-called burden of health and safety at work on businesses, which arguably has only seen an increase in the unscrupulous employers escaping the net of regulation. Many businesses, in reality, haven't seen a health and safety inspector for years. So what's health and safety at work all about? It's certainly not about putting additional burdens on business, nor is it about spoiling people's fun. Sensible and sensibly enforced regulation is about ensuring that workers, customers, and the general public can go home at the end of a working day. That's what my colleagues and I are all about. Enforcer, yes, but more to educate and equip business to be safe and compliant. Money spent on keeping people from harm is never a drain on resources. Safe business is good business, and you'll hear that one again. Once upon a time, bad employers paid little attention to the health, safety and welfare of their employees. If a worker was killed or injured, it was part of the job, and there would be others waiting to take his place on the shop floor. Thankfully, there were enlightened employers like the Cadburys and such politicians as Lord Shaftesbury who saw that their workers were an asset worth looking after. But it took many years for their enlightenment to pave the way for the legislation that we have today. And today we have legislation for health and safety at work, for food safety. We have licensing regulation that protects people. We have our fire and rescue service that are busy protecting people from the risks of fire. And of course, we have the planning, and Luke's already mentioned our planning webinar. All are key to the function of a safe and civilised society. And much of the legislation that a local authority deals with is about protecting the public, as you would expect. Regulation, good compliance is actually good for business. We all want to go home after a day's work with no injury, in good health, and as they say, in a good place mentally. We don't want to be made ill by the work that we do, and regulation gives us not only the right to enjoy this, but the tools to achieve it. If a business is plagued by work-related injury and ill health, including stress, hearing damage, and injury, how can it be as profitable as one that regards its workers as an asset to be guarded unless, of course, that business is run by unscrupulous people. Regulation, sensibly followed and sensibly enforced, gives us the coveted level playing field. So what is health and safety at work? Well, it's more than just compliance. It's a culture that starts at director level. Directors should understand that while the bottom line is important, a culture of compliance, including in health and safety at work, paves the way. Competence, and I stress the word competence, and we will revisit that later. Competence is a key word in health and safety legislation. A business is obliged to have competent help in meeting its duties. That doesn't mean, however, that you must have your own personal safety officer or the services of a health and safety consultant. A small business may be run by competent people, people who know the business and know how to make it operate safely. One of your employees might be a specialist in manual handling or safe lifting and is an untapped resource. What's important is the communication and consultation with your workforce. Cooperation and consultation are key. Compliance is about what is reasonable based on the risk. Risk being the likelihood of damage or injury, otherwise known as the hazard, multiplied by its severity. And to explain, imagine a balance, a set of scales. With risk on one side in one pan, it must be balanced by the necessary resources in terms of time, money, and effort to mitigate that risk. Therefore, the greater the risk, the more resources must be thrown at it to comply. Significant resources may not be necessary to mitigate a low risk. I'm paraphrasing case law of 1949, and it took until the 1974 Health and Safety at Work Act for the concept of reasonably practicable to be enacted. What health and safety at work is not is the ostrich mentality. It shouldn't be viewed through the eyes of the ostrich. Duty holders must face the responsibility to employees and others. However, you shouldn't just comply blindly because an inspector tells you to do so. I'm continually surprised that so little of what I ask for goes unchallenged. That may be more to do with our reasonable approach than ignorance on the duty holder's part. But my colleagues would all be prepared to justify their requirements by the standard of law or best practice. Did you know that our inspectors will always make the clear distinction between what is a legal requirement and what is good practice? So feel free to ask for chapter and verse. We'll talk more about legal requirements versus good practice later. But what does get my goat, or ostrich, is the vague statement that something can't be done for health and safety reasons. Oh, really? Explain. After many years of piecemeal legislation with vast numbers of working people having little or no protection, the Robins Report of 1972 led to the Health and Safety at Work Act of 1974, which gave for the first time protection to virtually all people at work, employees, the self-employed, and the general public insofar as they would be affected by work activity. And that was balanced by the duty on employees to work safely and to cooperate with the employer's duty to provide a safe workplace. Many of which are industry or activity specific, and arguably the UK led the way in Europe, making regulations later adopted by the EU. And one myth is that the EU imposed many health and safety regulations on the UK. The truth is that the UK was already ahead of the curve on that, and the EU followed. I spoke earlier about the distinction between law and good practice. Good practice is published in the form of approved codes of practice, or ACOPs. An ACOP has legal status, and complying with its requirements or measures of equivalent effect will normally be sufficient to demonstrate compliance with the law. The courts are likely to consider this to be a successful test of what is reasonably practicable. And it should be borne in mind that, like the defence of due diligence that we see in food safety, it can only be determined by the courts. Not following the ACOP's guidance is not an offence, but a court may decide that failure to follow that ACOP is a failure of the reasonably practicable test. And then there's guidance. And I don't want you to think of guidance with a COVID mentality. That is, oh, it's only guidance, so I can disregard it. As with COVID guidance, it's always intended for the wise to follow it. Let's bust a few of the myths surrounding health and safety at work. Expensive? Well, be prepared to put more risks into eliminating or controlling the higher or more complex risks. Difficult? Again, the greater the risk, the greater the effort required to control. But there are so many tools to help. The HSE website, professional organisations such as the Institute of Occupational Safety and Health, or IOSH, or from us here at Cornwall Council. While on the subject of myths, here are some of the more bizarre ones that I've come across, and a few half-truths thrown in. Number one, the HSE, Health and Safety Executive, has banned stepladders. Nope, stepladders, of course, should only be used for short-term jobs. They're not suitable for permanent access or where proper access equipment would be more appropriate. It stands to reason. A quick job to do, get the stepladder out, have somebody to hold it, be careful, do the job, put the stepladder away, job done. If you're going to re-roof your business premises, you may need scaffolding. Number two, office workers are banned from wearing open-toed sandals, only if a bloke wears them with socks. Stands to reason, doesn't it, that footwear should always be appropriate for the task. You wouldn't wear flip-flops on a building site. Number three, risk assessments must be carried out annually. Now, to my way of thinking, that's a recipe for box ticking. And we mentioned earlier that risk assessments must be done on significant change or when no longer valid. But there's nothing wrong with an annual review. Set yourself a date when you review your risk assessments. Has anything changed? Nope, sign it off and you're ready to go on for the next year or until something changes. Number four, small businesses are being strangled by over-regulation and over-inspection. Well, despite previous government's dogma on this, you'll be lucky to see one of my colleagues more than once in 10 years, unless you do something to attract our attention. Some common misconceptions. I've never had a safety incident. Well, neither did a guest house proprietor in Lou until his bed and breakfast caught fire in 2022. And you can read all about all of these in the following links. Someone else is responsible. Well, the duty is firmly on employers, but employees must take some responsibility to work safely and to cooperate with the employer. I'm a small business. I don't need to worry about health and safety. Whilst the level of regulation and requirements may vary depending on the size and nature of the business, if you're sending people to the moon, your risks are going to be significantly more than if you were running an office-based business. All employers must provide a safe working environment. Health and safety is just boring paperwork. Some paperwork is generally essential for evidencing that your safeguards are in place, but the real work is getting involved with staff and the operation of your business to identify your risks and eliminate or effectively control them. And then there are the half-truths. Yes, these are published statements. Local councils have banned hanging baskets on health and safety grounds. There's that dreadful term, health and safety reasons again. The truth was that one council suspended the use of hanging baskets until some unstable lampposts had been checked and repaired. I think that's reasonable precautions. And then you'll have heard the old chestnut, if you'll forgive the pun, schools have banned conkers. No. 2 schools took medical advice regarding the risk of nut allergy in some pupils, and one teacher actually issued safety glasses, but he did so to make the point of the increased fear of litigation. However, the media got hold of it and completely missed the point, which to my way of thinking is just lazy journalism. But the whole truth is that the UK is one of the safest countries in which to work since the introduction of the Health and Safety at Work Act. Workplace deaths have fallen by 75%, as a result of strong, sensible legislation. However, protecting of people at work is often trivialised by myths and half-truths put about by the press and politicians. There's no room for complacency, though. 10 to 20,000 people die annually from occupational cancers, and up to 2 million are affected by work-related ill health, including stress. And those are not my figures, those are from the TUC. If you think health and safety is expensive, try having an accident. It may be trite, but it does hold good. Only this year, a company in Newquay was fined over £60,000 for failure to take reasonably practicable, there's that term again, reasonably practicable steps to contain the spread of asbestos. Read about it on the HSE website. Last year, a £900,000 fine, nearly £1 million, was levelled on a company for failure to sufficiently consider the dangers of operating machinery via movable controls. And a family man was killed as a result. And a few years ago in Truro, we took a prosecution against the cooperative supermarket, who were subsequently fined £400,000 after a pensioner died after slipping on a wet floor. And the company had failed to deal effectively with a leaking sandwich chiller. And the poor gentleman walked in, slipped on the puddle of water, fell over, cracked his head, and didn't survive. You often see in supermarkets signs, caution wet floor. I would always ask the question, what have you done about the wet floor? Don't just put up a sign, do something about the wet floor. Mop up the water and find the source of the leak. Now, I don't like to use the E word unless I have to. We're more about advice, education, guidance, and giving resources. Local authorities' enforcement responsibility is primarily retail, wholesale, catering and hospitality, leisure activities, animal care, and consumer services such as tyre and exhaust fitters. And how we divide up enforcement responsibility with the Health and Safety Executive and other agencies is governed by, yes, you've guessed it, regulation. Leave us to worry about that one, and we'll point you in the right direction. We'd rather equip business with the tools to create a safe workplace than prosecute when things go wrong. And we've already mentioned that getting the right advice, competent advice to control risk. The first choice of a competent person is an employee with the appropriate skills. And a word of caution about buying in expertise such as from health and safety consultants. I'm not knocking them because many are former local authority or health and safety executive inspectors. They know their stuff. But what I have found over the years is that a consultant's brought in, gives the advice, and the advice lives on the shelf and is never used. It just gathers dust. Education, training, brilliant. Recommend our health and safety at work training as a starter. But sometimes enforcement action does become necessary, and we will use it where necessary. We can issue a schedule of works to be done, again, legally required, best practice. We could serve an improvement notice on the business. You must do this within a certain period of time. If something is of imminent danger, imminent risk to health, then we can serve a prohibition notice, which is an immediate stop. Or we can prosecute. Last resort. Failure to comply with a notice is an offence of itself, and we would probably prosecute for that. Failure to comply with a prohibition notice, in other words, to carry on with the operation, not a good idea. Recently, one unwise business owner has chosen to ignore a prohibition notice. He will have had better days. But to emphasise, we will always distinguish between what is a legal requirement and what is best practice or guidance. Culture, safety culture. A business's culture should have a big influence on the number of safety incidents that occur, but it needs management commitment. It needs a visible involvement of senior managers on the shop floor, and it needs good communication between employer and employees and an encouragement of open, honest discussion between them. And for senior managers, of course, read owner or proprietor according to the nature and size of the business. And we'll deal with safety culture a little later on. In fact, right now. Unfortunately, the health and safety executive, bless them, have prepared a useful safety culture template. It's really a gap analysis. Goes through a set of questions such as where is health and safety perceived to be in your management's priorities, senior, middle, first line. And I would say that if it's at the senior level only, it's nothing but lip service. Nothing will ever get done. If it's at the first tier only, and you've got very competent managers who are introducing safe methods of working, but you've not got the management, you've not got the senior management director level involvement in it, then they're wasting their time. The key phrase, I think, for us all to look at is risk assessment. Suitable and sufficient. What is suitable and sufficient? Well, unfortunately, that's another one that the courts only can decide what is suitable and sufficient. But at least you can have a good go at it and get pretty close to it. Suitable and sufficient assessment of the risk to employees and to non-employees. Don't forget those that may visit your premises, contractors who may come on site, people who are not your employees. And of course, it's linked to the size and nature of your business. All employers must assess the risk. Recording it is required if you have more than 5 employees, but it's a good practice to record it if you employ fewer. And thankfully, there's a template for that. And then review it on significant change or when you got cause to suspect that it's no longer valid. So you buy a new piece of machinery, it's going to work differently. So perhaps you need to do a risk assessment on it. What has changed? Does it introduce any new hazards? I haven't mentioned safety policies. Now, a safety policy is a requirement of the Health and Safety at Work Act itself. And a safety policy is really a statement of intent that every employer of more than 5 people, the Act actually says 4 or more, but it's the same thing. A safety policy to be prepared by the employer with his statement of intent on health and safety at work. And really it's coupled with the more recently introduced management of health and safety at work regulations, which specifically delved into risk assessment and coupled that with the need to provide a safety policy. With your risk assessments then, specific measures will need to be taken or at least considered if you're employing young people or expectant mothers, specifically required. There is a general duty to assess risks required by the Management of Health and Safety at Work Regulations 1999. But some risk assessments are also required by specific regulations. And you may well be familiar with the manual handling operations regulations and, of course, our old friend COSH, which many people don't know what it means, but it means control of substances hazardous to health. And there's usually a cupboard somewhere in the building or with the initials COSH on it, and it contains all your cleaning chemicals. It's really, the regulations are really designed if you're handling the very nasty chemicals and not so much for your general day-to-day cleaning chemicals, which come with full instructions. Let's revisit that term, competent persons. Those who assess risk must be competent to do so. And competence is defined by the Health and Safety Executive as the combination of training, skills, experience and knowledge that a person has and their ability to apply them to perform a task safely. So, one who is to assess risk must have an appreciation of the risks involved, and we can offer training to help businesses assess risk. Health surveillance may be required. For example, if you're working with certain chemicals, the more nasty ones, or substances such as asbestos, you're going to need competent specialist help. But we can say that an informed workforce is a safe workforce. So provide your staff with the information that they need to know to work safely. In terms of cooperation with other employers, imagine you are sharing business premises. You have a number of office-based companies within a building. If you share premises, then you should agree who does what. For example, who cleans the toilets. You may have heard this term, the hierarchy of control, or the principles of prevention. It's pretty self-explanatory, but first of all, the first principle is to evaluate, or is rather to avoid the risk altogether. If you can't do that, if you have to do that particular task, then look at it and find a safer way. Evaluate those that can't be avoided. Adapt the task to the employee and not the other way around. Embrace technology where it's reasonable to do so. And I'm thinking there that in days gone by, people used to lift and carry things around all over the place. And the number of back injuries was incredibly high. Then they brought in things like sack trucks and lift trucks and pallet trucks, and handling things and moving things around became so much easier because it had been mechanized. Replace the dangerous with the less dangerous. I'll come on to that in a moment. Aim for a coherent policy of prevention. And we all know that prevention is better than cure. If you can prevent an accident from happening, so much better than dealing with the aftermath. Another thing that I want you to hold on to is having collective protective measures over individual measures. We'll come on to that. I wouldn't have put instruction and training last in the hierarchy of control because, in my view, it's not the least important. Proper instruction, proper training should underpin all the other points in the hierarchy of control as the route to a safe workplace. Assessing the risk starts with a knowledge of your business. You may not be able to find the legislation applicable to a given hazard, but having that competent person will help in finding that. But knowing the hazard is the main thing. And the HSE website has a wealth of information which is arranged by industry and also by topic. So if you put in catering, the catering and hospitality page will come up, and it will take you to hazards such as slips and trips, the use of chemicals, falls from height, and lifting and carrying. But also such more interesting things as ventilation and migrant workers. However, if you're really stuck, a quick phone call to our business support team will help you to pinpoint the exact answer. The next thing to do is to ask yourself who may be harmed. For example, employees, customers, contractors. But you should consider those that are more vulnerable. We're looking at young people who may not be mature enough to be aware of the risks. Expectant or nursing mothers, considering their possible additional needs. Migrant workers, their first language may not be English. They may be unsure of their rights, or perhaps they're just unused to working safely in their country. There is no such thing as health and safety at work, and many people die as a result. And then there are people with a disability. And don't forget that your duty as an employer under the Equality Act 2010 to make reasonable adjustment, as well as your duty that you may have under the Health and Safety at Work Act. You may already be well on the road to controlling or eliminating the risk. What am I already doing? So applying the hierarchy of control then, what controls do I already have? And looking at the first example there, I've already got slip resistant flooring in my warehouse, and I have a floor that is slip resistant and it's kept clean and dry. So I've actually eliminated the risk. I've avoided the risk. Secondly, I'm using some pretty nasty cleaning chemicals. Do I really need them? Is there a safer way that it can be done? I once caught one of my restaurant proprietors in a local ironmonger's shopping for caustic soda. And I said to him, "Why are you using that?" He said, "Well, it cleans the drains." Well, haven't you got anything, can't you find anything safer that will do exactly the same thing? Oh, he said, "I'll look." Whether he did or not, I don't know. But say, for example, you have an aggressive cleaning agent. Well, you reassess it. Can I find a safer alternative? If you do, be mindful that that alternative doesn't create additional hazards. I'll give you an example. A cleaner at the council offices where I used to work had asthma, and she found that it was triggered by a certain cleaning agent that required mixing of a powder with water. And eventually, after a bit of persuasion, the employer sourced an equally effective cleaner that came in a pod which dissolved in warm water. And she was happy, had no more problems with asthma. It was a safe product, no additional hazards involved. And that's also an example of adapting the task to the worker. Who needs to carry out these actions? Is it something that needs capital expenditure, or can it be done on a departmental budget? Or are workers encouraged to offer solutions and empowered to make the necessary changes without having to always ask the boss? Keep a check on that, however. You don't want things creeping in that might be unsafe. What further actions do you need to control the risks? All right, you've already introduced a conveyor to cut down on manual handling, but packing line workers were complaining of lower back pain because the job still involved twisting, moving packages from one conveyor to another. What did you do? You rejigged the line, minor adjustments to the layout, and you reduced the twisting movements and therefore the back injuries to almost none. So how quick do I need to act? Well, if it's imminent and your workers are at a risk of serious injury, then of course you do it now, underline now. But we're back to the idea of reasonably practicable, and it may involve a certain amount of time before you can implement controls. It may be that you have to order some equipment which has a lead-in time. It may be that you have to carry out further risk assessments, design something, get it made, but can a safe but rapid fix be made now with a permanent solution later? You remember I said about collective protective measures over individual measures in the hierarchy of control. Individual measures I would class as including PPE, personal protective equipment. You've got a problem with flour dust in your bakery. Well, the simple answer to that is, of course, isn't it? Give everybody a dust mask. Think about that for a moment. PPE is usually the last resort when all other controls are insufficient, and PPE should be used in addition to other controls and not necessarily instead of. There are times when PPE is the only way of doing things, but your risk assessment will tell you what other controls should be put in place. And I hope the lesson on PPE was learned from COVID, that one size doesn't fit all, that substandard or the wrong PPE is as bad as no PPE, and that a mask for a biological hazard is unlikely to protect against dust. Usually it's less effective on its own without other control measures. Deal with the dust at source, for example. Put in extraction ventilation, or just change the way that you do things. Rather than throwing the flour into the mixer from a height, put it in gradually so that you don't get the dust given off. And PPE is usually uncomfortable and impracticable to wear all day. And simply giving our office cleaner a mask would not have done the job. It would have been insufficient. She would have still suffered the asthma, because chances are she wouldn't have worn that PPE for very long because it would have been too hot or too tight or just not suitable. And I want us to look at a risk assessment template. Again, bless them, the HSE have come up with a risk assessment template. So it asks you, what are the hazards? Who might be harmed and how? What are you already doing to control the risks? And what action do you need to further control the risks. Who needs to do it? When is the action needed? And then there's the column that you can sign off and say, yep, that's done. So let's look at a couple of examples. This is available on the HSE website, by the way. First example then, a fall of persons and goods from the upper stock area. Goods were being manhandled up onto the upper stock level, but there was no guarding, so there was a risk that people might be falling off, goods might be falling off, and so those working down below were at significant risk. So you put up a sign saying, beware, open edge, not good enough. You really need a suitable barrier and tow boards. So what do? Well, you close the upper stock area until that's done, or you load it with a forklift only. Don't allow people to go up there. But the action needs to be taken by the employer because it's going to need capital investment and there's going to be a lead-in time. So it should be done as soon as reasonably practicable. However, at the other end of the risk spectrum, your warehouse staff were suffering from cuts because they were using your ordinary modelling knife to open boxes, the bog standard Stanley knife. So then you replaced those knives with a knife where the blade was completely shrouded, ideal for opening things like strapping, taped box seals. But then there will always be those that will like the old modelling knife. So the further action you need to do is to monitor, are the new knives really suitable? Are they doing the job? Are they introducing any further hazards? You review that risk assessment periodically and see that it's still working, and you put additional measures in place to control the risk. Now, this was something that the warehouse manager took upon himself to do. Didn't need capital investment, just go and buy them on the budget that you already had. Job done, and you'll notice there that the risk assessment was carried out on the 1st of July, and within a week the matter was resolved. Everybody happy, fewer cuts to the packers. Risk assessment can be as complicated or as easy as the risk determines. Remember, the greater the risk, the more resources that you will have to throw at it. And so finally, we're here to help. And unashamedly, I'm going to reiterate that safe business is good business. Many businesses are compliant. Some may need a little help in getting there. Others just don't get it or care little about working safely. And others still won't get it because their eyes and ears are closed. And if you're in the first two categories, we'd love to help you. Chances are that businesses in the latter two categories won't be represented here today anyway. Much of the other legislation enforced by Cornwall Council is dealt with in the same way, a small dedicated band of officers with common sense and a desire to support our businesses in becoming the best that they can be. And one of my immigrant food business operators once paid me an enormous compliment. He told me that in his country, inspectors were focused on fault finding and just waited for him to fail and then prosecuted. Here it's different, he said, because you help me to get things right. And that's what we're here for. Helping you to get things right rather than mop up the mess afterwards in court. If you're stuck, give us a call. I work with people who have a wealth of knowledge, and a quick call to signpost information will cost you nothing. For more detailed work, however, we offer support on a cost recovery basis, either per hour or as a package. And while we'll help you with your risk assessments, we won't write them for you. That's your job, but we'll give you the tools. And there's some of the resources that I've mentioned earlier. There's a very interesting article on the definition of reasonably practicable. The HSE website is there, free to use, including the risk assessment templates. And then, of course, we have our own business support website. Please get in touch if there's further information that you need.